Welcome to our podcast. Today we are talking about justice, right to effective remedy and to fair trial, presumption of innocence and right to defense, Articles 47 to 50, learning objectives, knowledge and understanding of the notion of access to justice from the perspective of European law, identifying the elements that make up the right to a fair trial as well as their correct understanding. Content of the rights. Under international and European human rights law, the notion of access to justice obliges states to guarantee to any person the right to go to court or in certain circumstances to another body for alternative dispute resolution in order to obtain a remedial measure if it is found that the person's rights have been violated. Therefore, it is also a right that allows people to exercise other rights. In European human rights law, the notion of access to justice is enshrined in Articles 6 and 13 of the Convention for the Protection of Human Rights and Fundamental Freedoms and in Article 47 of the EU Charter of Fundamental Rights, which guarantees the right to a fair trial and an effective remedy as interpreted by the European Court of Human Rights and by the Court of Justice of the European Union, respectively. The right of access to justice in the EU Charter of Fundamental Rights may correspond to that contained in the European Convention. Therefore, the jurisprudence of the ECHR is important for the interpretation of the rights in the Charter. Despite the fact that the implementation of the provisions of the European Convention and the EU Charter of Fundamental Rights is governed by distinct systems, both emphasize and the idea of the need to implement first and foremost at national level the right to an effective remedy and to a fair trial. Access to justice allows individuals to protect themselves from the infringement of the rights, to remedy wrongdoing, to hold the executive branch accountable, and to defend himself in criminal proceedings. This is an important element of the rule of law and includes civil, criminal, and administrative law. Under EU law, the right of access to court means that courts should be accessible and be independent and impartial. The right to a fair trial essentially includes the right to equality of arms, which involves ensuring that each party has a reasonable opportunity to present its case under conditions that not disadvantage either party. The right to an adversarial procedure, which includes the right to be informed and to comment on any evidence. The right to a sufficient period of time to become acquainted with the evidence before the court, and the right to propose evidence. The right to a reasoned decision. Only a reasoned judgment demonstrates that a case has been properly tried and allows the parties to bring an appeal adequate and effective. The right to ensure the execution of a final judgment, failure to comply with or delay in enforcing a judgment may indirectly lead to a waiver of the right of access to a court. Interference by the executive branch by failing to make law enforcement available to the party, by the legislature by enacting a law annulling or nullifying an entire judicial proceeding, or even by the judiciary by admitting an extraordinary remedy as a result of the annulment of an entire judicial procedure, finalized with the pronouncement of a final court decision and which may have been enforced, led to the finding by the European courts of the violation of the right of access to a court. A public trial ensures the existence of a control over the judicial system. This helps to promote trust in the courts by visibly and transparently rendering the administration of justice. The right to a public trial also includes the right to an oral hearing. For example, in criminal proceedings in general, the defendant has the right to participate in a hearing at first instance. Legal aid. Access to legal aid is an important part of the right to a fair trial under Article 6 of the ECHR and Article 47 of the EU Charter of Fundamental Rights. The right to legal aid ensures effective access to justice for those who have insufficient financial resources to cover court costs such as court fees or legal representation costs. Legal aid does not have to take a certain form. States are free to decide how to fulfill their legal obligations. As a result, legal aid systems often vary widely. For example, legal aid may consist of free representation or assistance provided by a lawyer, and or exception from the payment of the legal cost, including legal fees. These measures may exist along with other complementary support schemes such as pro bono defense, legal counseling centers, or legal protections, which may be funded by the state, provided by the private sector, or managed by the NGOs. For example, in order to provide free legal aid to Roma in Hungary, the Ministry of Justice and Public Order has been operating the Roma Discrimination Network service since 2001. Lawyers who are part of this network provide free legal aid, legal advice or drafting of documents, legal action, bringing lawsuits and representing clients in court, in cases where the rights of their clients have been violated being of Roma ethnicity. The ministry covers the financial resources needed for the operation of the NERD network and the cost of filing lawsuits. The provisions of Article 47 of the Charter apply in the case of proceedings concerning all rights and freedoms deriving from the EU law. The Charter explanations confirm that legal aid must be available in cases where its absence would make it ineffective to guarantee effective access to justice. Reasonable time for trial. The Charter requirement that the case be examined within a reasonable time must be reported on a case-by-case basis, taking into account the length of the proceedings, the nature of the claims, the complexity of the proceedings, the conduct of the competent authorities, and the parties' attack. Judging the process within a reasonable time is aimed at removing the uncertainty in which the parties find themselves by restoring, as soon as possible, the violated rights and restoring legality, which must govern all legal relations in a state governed by the rule of law, a guarantee of a fair trial. In Sweden, the Court Quality Management Project has successfully reduced the length of proceedings before courts of appeal and district courts. The project aimed to obtain internal feedback of the management of the work of courts by judges and court staff. External feedback was also sought from defendants, witnesses, and lawyers. This dialogue took place through surveys, questionnaires, and small working groups. Action was taken on recommendation to improve the management of court cases and reduce the time required to complete cases. The right to an effective remedy under Article 47 of the EU Charter of Fundamental Rights applies to all rights and obligations guaranteed by the EU law. It is not limited to infringement of the rights enshrined in the Charter. Article 47 also explicitly guarantees access to an effective remedy before a court, thus providing extensive protection. Thank you for paying attention.